Next up, Barry Coffey's here to talk to us about, and I'm going to make sure I get the title right this time, cybersecurity breaches, data loss and fraud.
Thank you, Clarissa. So moving on to the sexy world of data protection. It's just a quick agenda. These slides in your pack, it's from a longer 40-minute talk. I've given you the slides so you can look at those at your pleasure. We'll just obviously quickly touch on the relevant parts in the next 10 minutes or so. That's basically what we're going to cover. So thinking about external threats versus internal threats to organisations, particularly commercial organisations. We'll have a look at the patchwork of data protection laws that exist around the world and the implications that this may have for your business or that of your clients. We'll then consider some of the remedies that are available to the corporate victims of cybercrime and data loss, the regulatory environment in which corporates are operating. We'll look in particular at the position here in England and the influence of European law. And we will then conclude with a very brief consideration of the emerging legal and regulatory environment. So, external threats. I'm sure everybody's been reading the news and they'll recognise the headlines up there on the slides. External threats are very real, and cyber hacking has caught the attention of the media over the past couple of years. As well as what appears to be straightforward theft, we also have state-sponsored industrial espionage. You may be aware that a number of large Western companies have suffered trading losses as a result of the nefarious activities of cyber spies and cyber gangs. Now, the narrative for the media is obviously very exciting. We have goodies, we have baddies. For the celebrities, for the red tops, we have celebrities. For the spies, we have for the broadsheets, we have the spies, and for the FT, we've got financial losses. But we should not forget that rogues and rascals obviously operate within organisations, and they can compromise both your confidential information, but also the personal data that you may hold within your organisation. And this, once they have this information, they can use it to perpetrate frauds. Just taking a moment to think about the internal threat and where this comes from. Obviously, employees, but also think about contractors and, importantly, weak practices within your organisation. A recent government survey has shown that many employees have a laissez-faire attitude. Employers have a very laissez-faire attitude to allowing their staff to use personal laptops, tablet computers, and smartphones for work business. Apparently 47% of UK adults now use their personal smartphones, laptops and tablets for work purposes, but apparently there's only 3 in 10 are provided with guidance on how to use those devices. I think that's quite important, because it's obviously very easy to to log on to corporate servers from personal devices. It's equally and potentially obviously very easy to potentially steal confidential information and personal data of individuals who are either fellow employees of the organisation, or potentially customers or clients of your organisation. So here's a global snapshot of the 100 companies that now have data privacy laws. It's a bit of a patchwork quilt, as you'll see. Anyway, the point to consider here is that if your organisation is the victim of some sort of breach which compromises personal data, this could lead to a fraud being perpetrated. Now, what happens then? Well, they could be faced not only with disgruntled customers, they could also be hit with class actions potentially. But now they will also attract the attention of data protection regulators. And this map demonstrates that a significant number of countries have now introduced data protection laws and have got data protection regulators with beefed up powers. And what I mean by that is, if there is a loss of personal data and it is found that the organisation is at fault, or sometimes even not at fault, they could be hit with a fine by an ombudsman, or the ombudsman in this country, or a similar data protection regulator. Now, I've set out a quick scenario here for consideration, so I'll give you all a moment to have a quick look at that. Now, what do we do? Firstly, we don't panic, because what we'll do is investigate. So we'll work out who's responsible, what's happened, where this has happened, when it's happened, and how it's happened. And here are some of the remedies that are available in England to corporate victims. So immediately you could go along to court, get an injunction, get a delivery up of documents, document destruction order, as Mark was referring to a few moments ago. That's what you can do immediately to try and quarantine the situation. Now, what are the advantages of doing this? Well, hopefully it will prevent further data loss prior to the commencement of proceedings. It could allow your organisation to recover data that's been lost. But importantly, an additional important point, it may also assist you, the organisation, in persuading the data protection regulator that your organisation has taken relevant steps to mitigate further data loss. And the upside of that, of course, would be that hopefully you wouldn't get fined, or to the extent that you would get fined, such fine would be significantly lower. Another potential remedy that you could pursue, which I haven't put up there, would be a Norwich Pharmacal Order. Now, a Norwich Pharmacal Order requires a respondent to disclose certain documents or information to an applicant. What we need to remember here is that the respondent must be either involved or mixed up in a wrongdoing, whether innocently or not, and it is unlikely to be a party to the potential proceedings. Now, Norwich Pharmacal Orders will be provided where it's necessary in the interests of justice. Now, these orders, as you probably know, are commonly used to identify the proper defendant. So if you find that a whole bunch of personal data has gone missing out of your organisation, you don't know who's done it, what you can do is go along to court, get a Norwich Pharmacal Order against potentially Gmail or Hotmail, or a peer-to-peer file sharing site, for instance. You can get information from that particular organisation, and then you can use that information to find the proper defendant, i.e. the person who has effectively stolen the data. Just pondering there, what would you do then if you were then to carry on and pursue the action against that proper defendant? Well, you've got breach of contract, breach of fiduciary duty, breach of confidence, tort of conspiracy. There's a whole arsenal available to you to go after this individual. I've also put up there the options that are available for prosecutors. We won't ponder on that, but if anybody would like to have a chat, then do come find me afterwards. Now, please pay attention, because this is the really interesting bit, the regulatory environment in which corporate entities operate. I've just sketched out there data protection laws and how it affects the UK, has affected the UK since 1995. The point is that we've had a regulator here in the UK for a number of years, the Ombudsman. It's generally taken a fairly laissez-faire approach, in stark contrast actually to our cousins in France and Spain, and also in the United States, where regulators are far stricter and far more willing to fine organisations where there's been personal data losses. However, things are changing. You'll see there, early 2017, general data protection regulation is anticipated to come into force. Now, what does that mean? Well, the new regulation will mean that, if you just look at the bottom bullet point there, breaches or personal data breaches will have to be notified to regulators without undue delay. This piece of legislation is still doing the rounds in Europe, but it's considered that will probably mean within 72 hours. If you look at the bullet point immediately above that, you'll see that fines of up to 5% of an enterprise's annual worldwide turnover, or 100 million euros, can be whacked on an organisation if it's found that there's been a breach and that personal data has leaked out of that organisation. So I think I'll conclude there by just saying that the position now is that if your organisation operates and uses personal data of employees, which it probably does, of clients or of customers, you need to be careful, because if that data finds its way out of the organisation and if it is misused, then not only will you find yourself on the end potentially of proceedings, but also of a very big fine from data protection regulators. Thank you very much.
Thank you, Barry. So a few years ago I had a call from a client who said a website where people were logging on with their jobs had been hacked into, and everyone's personal details were available, and it was in the press because it was and it happened to be owned by a news company. So at that point, the biggest issue was reputation. Who would ever use their jobs boards in future if they were open to the public and hackable with detailed information? But now the consequences are obviously much worse. So thank you, Barry.